My name is Michael Froomkin, and I'm going to be teaching jurisprudence as a first-year elective this coming spring. The idea behind this video, or so I'm told, is to try to give you some idea of what we're going to do. And I think that's an excellent plan because jurisprudence is, first of all, not a course probably that you heard much about before you came to law school or even in law school. We have not offered it for several years. And second, it's one of the least standardized courses in American law schools. Different schools teach jurisprudence very, very differently. I've started teaching this class back when I first got to UM almost 30 years ago. And I've taught it on and off since then, but mostly off for the past few years. And I'm really delighted to be able to pick it up again because I have so much fun with this class, and I hope you will too. Jurisprudence is about the theory of law, the nature of law, and very occasionally the law of nature, although not mainly that. The course materials, which I put together myself, although using models from some pretty famous people out there, draw from legal philosophy, from domestic and international law, from social science, and from the news. And I hope they're going to provide us occasions to do at least three different things, more or less simultaneously. First of all, and most importantly, we're going to explore some basic questions relating to the ways in which so-called laws are formed and recognized, including a question you may think is really obvious, but turns out to be far more difficult, I suspect, than you ever thought. And that is, what is a law? What makes something a law? Law, after all, as we teach it in a law school, is not quite like the laws of physics, but it's also not like the laws of social science. Some people say that it grows out of sociological or biological phenomena, natural laws. We'll talk about that a little bit. Some people say it's an art form or a socially created delusion, and we'll talk about that a little bit too. We'll also talk about who gets to set laws, or who gets to find and declare that something's a law. How do we know a law when we see one? It's a big question, certainly for somebody who wants to be a lawyer and sell their services. How do you know a law when you see one? Again, you might think, well, I just go to the law library and look it up. But as I hope you're beginning to discover, it's not nearly as simple as that. And once you identified the consensus belief around you as to what a law is, what can you do with that fact? What does it mean to know what the law is? How do you get to use it? And of course, all of these lead up to a related question, which is when, if ever, does the law actually matter? Now, what you'd say, well, what does all that mean? Well, here's a concrete example of a sort. Why is it that the rule you should stop at a stop sign is considered to be a law, but the rule that you should not talk with your mouth full is not considered a law? Now, a classic answer is that the legislature passed a law about stop signs, and or that it's found in a statute book in the library somewhere. And that's why that's a law. And the thing about talking with your mouth full is not a law. But it's not that simple, right? Some statutes are dead letters. And although they're in the statute book, nobody enforces them. And if you went to a cop and asked them to enforce the law, they'd laugh at you. So how do we tell if a given statute is live or not live? And if you think sanctions, right, the willingness of some authority to punish people for breaking the rule is what makes a law. Think about what happens to 6-year-olds who try to talk with their mouth full, at least in some households. And also think about the question of whether if you have a law that nobody is willing to enforce, whether it still counts as a law at all. And if sanctions are the answer, then are the rules of Major League Baseball a law? After all, if you break the rules, things can happen to you if you're a player in the major leagues. And of course, as you've already begun to discover, lots of laws are not statutory at all. They might be international, constitutional, common law, administrative, or even unwritten. How do we find those? And what happens if when we go look up a law in the library, it turns out that it was misprinted, or that it was printed the way that the legislator reported out the statute, but that was actually contrary, due to some typographic accident, from what the author of the bill proposed and maybe what the actual House or Senate voted. Maybe they left out the word not somewhere. It might be a big difference. But what if it's just crazy? Is it a law? Again, a specific example. There's something that's known as the 27th Amendment to the Constitution. But is that really an amendment? Is it really part of our law? Given that the first few ratifications were in the late 1700s, but a majority of them came in the 1980s from states that didn't even exist when Congress first proposed the amendment as a part of the Bill of Rights. You have to dig pretty deep into your political theory to decide whether or not that's legitimately part of the law. Now, the second thing we're going to do, while discussing all kinds of interesting questions like that, and whether a tomato is a fruit or a vegetable for legal purposes, is to evaluate a variety of legal arguments. Ideally, by participating actively in class, you'll learn how to make better arguments and how to recognize a number of standard moves, some better than others, that recur in legal arguments and how to respond to them. I promise to enact various forms of both good and bad arguments and to ask you to respond to them. This is a discussion-heavy class. And third, not least, but probably least in time, the amount of time we'll spend on it, the choice and organization of the materials that I've created encode an argument about one aspect of law, about the relationship between international law and domestic law as to their nature. So a lot of people say, well, international law is not law. The materials are going to give you tools with which to think about that, and I hope a deeper and more interesting way. And I hope you'll form a view on that issue by the end of this semester. Anyways, I said this is a discussion-heavy class. There is going to be a final closed, probably open book actually exam. Come to think of it, because it's going to be online. It's cross-listed, I should mention, for 2Ls and 3Ls. To the extent that any of them take part in the class, and it's usually very few because it meets on a Friday, and if there's one thing 2Ls and 3Ls don't want, it's a Friday class. Their exam will either be different or in any case not graded as yours will. Be graded in separate piles. And unlike yours, it may not be curved. All right, that's it. I'm happy to answer any questions by email. If you'd like to send them to me, it's Froomkin, Froomkin, @law.miami.edu.